Section 12, ADRE Advertising Investigations, How Small Advertising Mistakes Can Cost You Your License. ADRE Advertising Investigations, How Small Advertising Mistakes Can Cost You Your License. By the following Wednesday, Ashley thought she finally had advertising figured out. She had updated her business cards, added the brokerage logo to her social media pages, verified her website, identified the brokerage, and even had Michael review a new listing flyer before publishing it. As she walked into the morning sales meeting, she noticed another investigation file sitting on the conference room table. She smiled. "I think I know what's coming." Michael laughed. "You probably do." He held up a printed screenshot of a Facebook advertisement. This advertisement generated exactly one phone call. Ashley looked at the advertisement. "It looks pretty good. Professional photographs, a great property description, excellent marketing. I don't see the problem." Michael smiled. Neither did the agent. David picked up the advertisement. The problem wasn't what was on the page, it was what wasn't. Ashley looked again, then she saw it. The brokerage. Michael nodded. The employing broker's name was buried in tiny print at the very bottom of the advertisement. Technically, it was there, but consumers couldn't reasonably identify who was responsible for the advertisement. Ashley frowned. "So someone complained?" Michael nodded. "Actually, another realtor did." The room became quiet. Michael explained that one of the biggest misconceptions among licensees is believing that most advertising complaints come from unhappy buyers or sellers. In reality, he said, many advertising complaints come from other real estate professionals, competing brokers, competing agents, association members, consumers, and sometimes from ADRE investigators who happen to see the advertisement themselves. Ashley looked surprised. "So anybody can file an advertising complaint?" "Absolutely," Michael replied. "And once ADRE receives that complaint, the investigation begins." Michael projected the complaint timeline onto the conference room screen. Complaint received, advertisement reviewed, broker contacted, investigation begins, disposition. Ashley looked at the timeline. "I thought ADRE just looked at the advertisement." Michael smiled. "Almost never. When investigators receive an advertising complaint, they usually begin looking much deeper." David nodded. "They'll review websites, Facebook, Instagram, LinkedIn, YouTube, Google Business, email campaigns, digital advertisements, teen pages, printed flyers, business cards, open house signs, and sometimes months of previous advertising." Ashley laughed. "So one Facebook post can turn into an investigation of everything." "Exactly," Michael replied. "And that's why advertising compliance should never be treated as a one-time event." Michael reminded the class that Arizona broadly defines advertising under ARS Section 32-2101, and the Commissioner's advertising rules contained in AAC R428 5R2 apply regardless of whether the advertisement appears in print or online. Today's marketing environment may include websites, blogs, social media, email campaigns, podcasts, streaming video, AI-generated content, text messaging, and digital advertising. The technology continues to evolve, but the legal principles remain the same. Advertising must be truthful, identify the employing broker in a clear and prominent manner when required, avoid misleading claims, and comply with Arizona law. Ashley raised her hand. "What happens after ADRE decides there's a violation?" Michael smiled. "That depends." He explained that not every advertising violation results in severe discipline. The commissioner's goal is consumer protection, not punishment. In many situations, ADRE wants voluntary compliance. He explained that when violations are relatively minor, the commissioner may issue a letter of concern under ARS Section 32-2153F. A letter of concern is not formal discipline, but it becomes part of the licensee's record and serves as notice that the advertising practice should be corrected. If similar violations continue after the licensee has been warned, that previous letter of concern may become important evidence supporting more significant disciplinary action. David smiled. "I tell every new agent the same thing. If ADRE sends you a letter of concern, treat it like your free warning." Ashley laughed. "That's probably good advice." "It is," Michael replied, "because the next conversation may not be as friendly." Michael then held up another advertisement. This one was created entirely with artificial intelligence. Ashley smiled. "I've been experimenting with AI." "So have most agents," Michael replied. "And AI is an excellent productivity tool. But here's what AI cannot do." He pointed toward the advertisement. "It cannot verify facts. It cannot confirm square footage. It cannot determine whether HOA information is accurate. It cannot guarantee investment returns. And it certainly cannot assume your brokerage advertising complies with Arizona law." David nodded. "The moment your name appears on that advertisement, it's your responsibility." Michael smiled. Not the AI's, not your marketing company, not your assistant. Yours. Ashley wrote another note. Technology never replaces responsibility. Michael noticed. I think that's going on my office wall. Everyone laughed. He continued. One mistake I see becoming more common is agents assuming that because an advertisement disappears after 24 hours on social media, it disappears forever. Ashley smiled. It doesn't? Michael laughed. No, someone always has a screenshot. The room laughed with him. He explained that digital advertising creates permanent evidence. Even deleted posts may exist in screenshots, archived web pages, email marketing systems, or transaction files. Agents should assume that every advertisement they publish could someday be reviewed by their designated broker, an ADRE investigator, an administrative law judge, opposing counsel during litigation, or a jury. David leaned back in his chair. I have one simple advertising policy. Ashley smiled. What is it? If I'm uncomfortable seeing the advertisement projected onto a courtroom screen, I don't publish it. Michael nodded. That's excellent risk management. He explained that before publishing any advertisement, every licensee should ask a few simple questions. Is every statement accurate? Can every claim be verified? Is the brokerage properly identified? Does anything create a misleading impression? Would I be comfortable explaining this advertisement to an ADRE investigator? Ashley looked around the room. You know, advertising really isn't about marketing. Michael smiled. No, it's about credibility. Every advertisement tells the public something about the professional behind it. Good advertising builds trust. Poor advertising invites questions, and misleading advertising invites investigations. He gathered the advertisements and closed the file. The easiest advertising complaint to defend is the one that never gets filed because you reviewed your marketing before you clicked post. Real-world Arizona example. An Arizona salesperson created an attractive online advertising campaign featuring drone photography, professional videos, and social media promotions. Although the marketing generated substantial interest, the employing broker's name was not displayed in a clear and prominent manner on several digital advertisements. A competing licensee submitted an advertising complaint to ADRE. During the investigation, ADRE reviewed not only the original advertisement, but also the salesperson's website, Facebook page, Instagram account, YouTube channel, and other online marketing. While most of the advertisements complied with Arizona law, several required corrections. The investigation concluded with corrective action and served as a reminder that every advertisement published online may become part of an ADRE investigation. Broker tip: develop an advertising compliance checklist before publishing any marketing. Ask yourself, is every statement accurate and verifiable? Is my employing broker clearly identified? Have I avoided guarantees, misleading statements, or exaggerated claims? Would I feel comfortable explaining this advertisement to my designated broker or an ADRE investigator? Taking 60 seconds to review an advertisement can prevent months of responding to an investigation. Online discussion question 1. Why do many advertising investigations begin with relatively minor mistakes instead of intentional misconduct? Model answer. Most advertising violations result from oversight rather than fraud. Small errors such as missing brokerage identification, inaccurate statements, or misleading wording can still create consumer confusion and trigger an ADRE investigation. Question 2. Why should licensees treat every social media post as though it may someday be reviewed by ADRE? Model answer. Digital content is easily copied, shared, archived, and preserved through screenshots. Even deleted posts may later become evidence during an investigation or legal proceeding. Question 3. Michael says advertising is really about credibility rather than marketing. What does that statement mean to you? Model answer. Every advertisement reflects the professionalism and integrity of the licensee. Truthful, transparent advertising builds consumer confidence, while misleading advertising damages trust and may result in disciplinary action.